Thank you, Your Honor. Good morning again. May it please the court. Analysis of this case should turn on three basic questions. First question is, will the court be applying 18A or 18C when determining how to process Alicin, Alicin's intestate estate? She died some 20 months after its effective date. Appellant's position is that 18C should control and is a gateway to the analysis. The next step along the analysis under our framework is to determine whether or not subsection 2117 of 18C will be the operable subsection, figuring out how do we determine whether or not Amber, Alicin's child who she gave up for adoption, should inherit. Finally, and our position is that that is the right test, and certainly as part of 18C should be used. Finally, under this framework, this court must decide if the adoption decree, as signed by Judge Childs in 1992, makes provision for Amber to inherit. That's our position. I welcome the court's questions.
Well, let me ask on the first point, 18A versus 18C. How do you interpret the language in 18C 83012A1 that says the intestate succession provisions of Article 2, Part 1, Subpart 1 apply, while this, Section 2117, is Subpart 2?
Thank you, Your Honor. The court has addressed this already, or addressed this particular subsection in the O'Donnell case from March earlier this year. And in that opinion, the court noted extensively in footnotes and in its text that this particular subsection was a corrective subsection that was meant to clarify whether or not intestate laws should be analyzed as to when it should be analyzed, right? So there's, at the beginning of that subsection, it says the effective date of this is September 1st, 2019. And then there's a further clarifying thing. The clarification does not render 2117 a moot or extraneous statute. Also, if you look under the same subsection, Justice, to F, you'll notice that F is also pointing to 2117. So sub F says, hey, let's talk about 2117 because it matters. And then if you look at other parts of 18C, specifically Article 9, there are a couple instances where it references 2117 as having some significance other than none.
Well, you're saying that F is relevant to your argument because it talks about adoption decrees entered before January 1, 1981. So your argument is this reflects that if the adoption is after 1981, then 2117 18C should apply.
After 1981, that's correct, Your Honor. I mean, F, in our view, is doing double duty there, and so but I'm answering the question in this case saying, hey, you know what, it's there and it's pointing to 2117. 2117 is clearly operable.
Well, let's look at D, subsection D. It says any accrued right is not impaired. And the argument, obviously, is you don't have any right to inherit until the decedent dies, correct?
That's our argument, Your Honor, yes.
But here what we're talking about is a status of a child. And that occurred at the time of the adoption decree. So isn't there a little difference about you're changing the status of this child as a child who the biological mother has given up certain rights, but she has also retained a right to give that child natural inheritance. So is there a difference with a status right like adoption as opposed to just the generic right to inherit?
I think there is, Your Honor. I think that her status was firmly established in 1992. Amber was adopted, right? So Alicin was her natural mother, and then Alicin is the adoptee. That status has not changed. What we're looking to is to figure out, okay, now that Alicin has passed, while 18C is effective, what results? And so.
But it's your definition of what is the definition of an adopted child, which seems a little different than other kinds of rights that can ebb and flow. You were adopted at the time of the decree as a child, but it meant you did not give up the right to inherit. Now, that the biological mother can always write a will or something, but the status of the child is someone who retained that for the purposes of defining what an adopted child is.
Right.
So can the definition change over time?
I don't believe the definition can. Amber continues to be an adoptee. And she was an adoptee when Judge Child signed the decree. She's an adoptee today, although an adoptee whose natural mother has passed. The question is, what do we do? What provision has the legislature made for determining where an adoptee falls within the intestacy process, right, and figuring out what to do? Lots of things change from the time that somebody's status is initially determined. For instance, a biological parent, when a biological child comes into the world, has that day the ability to inherit from that child by virtue of being a biological parent. That status can change over time if that parent loses his or her parental rights. That status can change over time if there is a change in the statute. There's been a change in the statute too. So had Alicin passed the day after the decree, 18A would control, and we wouldn't be having any of these conversations. But that's not what happened. The law changed, and there's 100 years of case law that suggests that the current title, whatever is true today, is applied to the child. And the child in this case is an adoptee, and there is a special provision in the statute that says, hey, here's what we do with adoptees. We say that that they may not take unless provision is made within the adoption
Well, I'm
decree.
going to move you to that question then. Even assuming that 2117 applies, it says, however, the child may inherit, the adoptee may inherit, if so provided in the decree. First, I guess I would say, I mean, what is the standard for determining whether it is provided in decree? What do we do if there's an ambiguity in the decree?
Right, and I think that's exactly the nub of this particular case, right? So what do we do if there's an ambiguity?
Well, if they're normally in a contract, if there's an ambiguity, if you were interpreting something like a contract, or for that matter, you might do it as well for legislation, you would look at the intent.
Correct.
And so therefore, the consents and the other documents that are filed as part of the stipulated facts would certainly support the conclusion that it was intended to provide.
But the legislature does not query the intent of the court, of the judge that signed the adoption decree. The statute does not query what was the intent of Alicin.
So you're positing then that it has to be absolutely clear and unambiguous, otherwise it can't be considered to have provided.
It would be helpful if it was absolutely clear and
I understand it would be
unambiguous.
helpful. If we wouldn't be here if that were clear.
Agreed, Your Honor. So
I have a couple of questions for you as well about the judge's determination that application of Title 18A was in the interest of justice.
I'm sorry, it was in the interest of...
Do you agree that the adoption decree satisfies Title 18A? I mean, I'm assuming that's why you're arguing that 18A does not apply.
Well, I mean, 18A applied to establishing Amber's status as an adoptee. I do concede that, of course.
And, okay.
I'm sorry, I don't know if I'm understanding.
It strikes me that the form of the adoption decree satisfied the requirement of former 18A because former 18A said specifically that adoption of the child by the spouse of a natural parent has no effect and does not affect intestinal succession.
Correct, Your Honor. And if we were applying 18A and it was prior to September 1st, 2019,
Well,
I'd be right there with you.
I guess my question for you is it fair and just to apply a subsequent statute to a form that was valid under the prior statute? I mean, doesn't that argue that in the interest of justice, we should measure the validity of the form by the law that was in effect when the form was generated and signed?
I don't think so, Your Honor. The legislature had every opportunity to make that determination. They wrote 2117 the way they wrote 2117.
To change the decree?
No, they don't change the decree. They just say, hey, when we're trying to figure out how to, what to do for Amber as the adoptee.
I think what I'm sort of hear Justice Horton saying is that in 2000, at the time of the decree, under 18A as it then existed, this is a decree that provides for the adoptee to inherit.
I disagree with that, Your Honor. I don't believe that this decree does. I believe there's a space for the decree to do it. There is a clause that starts if the adopting parent is ... unless otherwise provided here, and then there's nothing but space.
But isn't the ...
Childs did
that
nothing.
you just went through important? Because what it says is that to the extent that it doesn't change the circumstance of the adoptee, unless there's something to the contrary in the space that's blank that you're referring to.
If I may, Your Honor, I appreciate the question, and I have a little grid here to help me with the analysis. This is not my favorite kind of analysis. Nonetheless, let me take a shot at it, if I may. The predicate clause, if the adopting parent is not the spouse of a natural parent. So right out of the gate, we have ambiguity, and we have a form that isn't doing all the work it should be, because there are two adopting parents. And we see that in another part of the form, right? Both Edward and Rebecca adopted. And here, it just sort of says, well, if the adopted parent is not the spouse of a natural parent. Now, Rebecca, if we run Rebecca through that test, then the answer is, well, she is the spouse of a natural parent. And our view is, therefore, one answer could be, I know there are two answers possibly here. One answer could be, the test is irrelevant. She fails the predicate.
If the decree isn't valid under Title 18A, which is seems to be what you're suggesting, why does it matter which version of the probate code applies?
Well, because I believe that it's not a question of which. I'm sorry, I'm not sure I understand the question, Justice. Let me.
Okay. I'm inferring that you oppose the application of the probate court's application of Title 18A in this case because the decree satisfies the requirements in terms of preserving Ms. Hansen's right to intestate succession.
We oppose it because we don't think it applies. The effective code title was 18C, not 18A. That's why we oppose its application. So we're not using 2109 to figure out what to do.
Thank you, counsel.
Thank you.
I think you've reserved some time for rebuttal. Attorney Bailey.
Thank you, Your Honors. May it please the court. Both appellant and I agree that an adoption decree can override the default intestacy provisions of the probate code. This is true both under 18A and 18C. The default provisions are there when there is no clear testator intent. In the case at bar, the testator's intent is clear. She wanted her daughter to retain her inheritance rights. Per Alicin's instructions and her consent, not once but twice, the adoption decree provides for the right of Amber to inherit from her mother's estate, or if the court were to find that it does not as currently written, then the case should be remanded to the probate court to amend it as requested in the lower court. The law in effect at the time of Amber's adoption, as well as the adoption decree, preserved Amber's right to inherit. The intent of 18C, that the law in effect at the time of the consent and the decree, can be found in 9-108, as well as the exclusion of Article 2, Subpart 2 from 8301 2A1. 18C2117, heavily relied upon by appellant, provides that a child may inherit from their biological parent after an adoption, if so provided in the adoption decree. 2117 does not specify how the adoption decree has to, quote, provide, close quotes. 2117 does not require an affirmative grant of inheritance rights as asserted by appellant. Adoption is a statutorily created construct. The court is, by granting an adoption, redefining the family relationship between the parties. How those relationships are legally redefined is controlled by the laws in effect at the time of the granting of the adoption, as well as the decree itself. In the case at bar, both the statutory law and the decree are clear that the reconstructed legal relationship between Amber and Alicin did not affect Amber's right to inherit from Alicin. Thank you, and I'd be happy to answer any questions.
Can I clarify then something, that even if we were to apply 18C, it's your view, obviously, that this decree does provide for the inheritance, correct?
Correct.
Is that because the decree itself has clear language saying so, or is it more that this is a decree that, as written, under the law as it existed when it was entered, would have provided for that inheritance, the effect of this decree in the law as it existed at the time, and there was nothing additional needed, in other words, in order to provide for that inheritance at that time?
I think both, Your Honor, and what I mean by that is that obviously when a court order is written, a decree is a court order, it is also incorporating laws in effect at the time. And as we saw in this case, there's some what's known as boilerplate language that does reflect the law at the time. Obviously, a judge with a order with pre-printed language, if you will, can and often does change that language if they want to detour from the statutory language.
Do you agree, or what's your position if the court decides that 18C does control, that we're not going to look at the previous law, so we're stuck with 2-117 and the operative language in the decree here? Do you concede that that is case closed, case over, that there's no way that the adoptee can inherit under that circumstance?
I do not agree. I think
Okay.
even if this court...
My follow-up question is probably what your follow-up answer was going to be, which is, if we look at the operative language, that sentence there that we've been quoting from, it does address a specific situation. It addresses a situation where the adopting parent is not the spouse of a natural parent. That's the scenario that language addresses, but we agree that that's not the situation here. Is that as far as it goes there? Because we know here that an adopting parent is, in fact, a spouse of the natural parent. So that the language deals with the other situation where it is not, and that's all it deals with. Doesn't that leave us out in the cold? Am I making that clear?
I don't think I'm clear on your question, Your Honor.
As we know, an adoptee may, however, inherit from the adoptee's former parents if so provided in the adoption decree. So I'm looking at the adoption decree. I'm trying to see if it is so provided in the decree, and I can't find language here that says that the adoptee here shall inherit from the natural parent.
Again, Your Honor, I don't think that 2117 requires an affirmative granting of preservation. Maybe you're not reading from 2117.
If so provided in the decree, it sounds like it has to be written right in there. If it's so provided, not that it incorporates or implies or assumes that other circumstances applies, it has to be so provided in the adoption decree.
Okay. Again, Your Honor, if this court were to find that the adoption decree didn't so provide, to use that language, then I think that the decree needs to be amended, because certainly the consent signed by Alicin was based on and part of an integral part of her granting consent to this adoption was that the inheritance rights would be preserved. So if the lower court made a mistake when they granted the decree and did not reflect that, then that needs to be amended.
Yes, I saw that you got the consent there, where she says, I do expressly consent, and we wouldn't be here today if the court had written in what the consenting parent had proposed or required.
Correct.
But counsel, just so I'm clear on your position is that the decree as it stands now does provide for the child to inherit because it doesn't provide otherwise. Where the judge would have had an opportunity, if that were his decree, he could have filled in where it is blank and specified the outcome, but he did not do that. So if you just read the plain language of the provision, you arrive at the conclusion that the decree does provide for the child to inherit.
Correct, Your Honor.
Thank you.
Counsel, what if we look at that same language that Justice Douglas was referring to, and we find that that's ambiguous? What should we do in that context?
Again, Your Honor, I would look at the intent at the time as reflected in the consent. And
So resorting to extrinsic evidence as to what the intent of the decree was to have been?
Yes, again, that consent is an integral part of the granting of the adoption. I mean, the question becomes if someone consents to an adoption and as part of that, as in this case, that they wanted their child to retain inheritance rights, and the probate court doesn't follow that. I mean, what does that do to the adoption? Does that void the consent, and therefore the adoption is not valid? I would posit that the more reasonable avenue for the court to take would be to just amend the decree.
And what to be made of the point that the opposing counsel alluded to, that the adopting party here is actually one of the natural parents of the child?
Yeah, and I think that is why, and I don't know this, but I think that is why the consent was signed in two places, so that Alicin was making it clear that both the non-natural parent who was adopting, that was the first part of the consent. But if you remember the consent, she also signed under another section for, and I might have reversed those, I apologize, for the non-natural parent, that in either scenario, she was saying, I want Amber's inheritance rights to be preserved.
At the time of the adoption decree, when we were still dealing with 18A, at that point, did the adopted child have a vested right in that inheritance? Had that right vested, or is that a contingent right that comes into being at the time when the natural parent dies?
She had the same vested right, if you will, as any other natural child of a parent. And the effect of the adoption did not change that.
I mean, the parent could have, Ms. Daggett could have divested her of any inheritance by creating a will or other provisions for the estate.
Absolutely, yes.
And the fact that the legislature then passes a new set of laws governing intestacy and so forth, that can affect adopted as well as natural children's rights.
Correct, Your Honor.
At the time the adoption decree was entered in 1992, there was no requirement that it provide specifically for the adoptee to inherit from former parents if specifically provided. Was there?
I'm sorry, if you could repeat the question,
Okay.
please.
In other words, I just want to confirm my understanding that as of when the adoption decree was entered, the statement in there was no requirement that the adoption decree affirmatively provide that the adoptee inherit from the former parents.
Not if it was a step-parent.
Okay. And thank you.
There don't appear to be additional questions. Thank
All
you.
right, thank you.
So circling back, Chief Justice, to your question earlier, you started to go down a path asking me about contracts and what do we do with contracts when we have ambiguous language.
Well, how do we interpret this? If we assume that this decree language is perhaps not as explicit as you would like, or as 2117 might suggest, what do we do with that?
So I believe that a court's decree is different than legislation, which is subject to interpretation by the courts generally. I believe that they're certainly different than contracts, right? This
Do you
is not a
think her
contract.
consent decree has no relevance to this analysis?
Well, I don't believe that it does.
So you're saying if it's ambiguous, you have to resolve it against her?
I'm saying that I'm not saying that, Your Honor, and I'd love to be able to say that because then I'd win and I could just go home, but I'm not saying that. What I'm saying is that we do not look to Alicin's intent to figure out what the judge should have done. Judges are not recorders.
Well, not what the judge should have done, but what the judge did do. If we suggest that use of this language, it doesn't affirmatively say she will inherit. However, it certainly at least raises the issue. And if we think that that language is at least ambiguous, how do we resolve that ambiguity?
I believe you resolve it in favor of in light of the import of the document itself, right? So you might be able to infer from a contract. You might be able to infer using legislative history from legislation. But this is a court order. I think you have to look specifically to the provision.
But we have to look at it in the context of when it was entered. And it was entered at a time when there would be a right to inherit. So you didn't have to say much. You didn't have to say anything at that time. So why should we require them to say an awful lot that they didn't have to say at the time?
So, Your Honor, I don't agree that court decrees necessarily incorporate the entirety of the legislation and the statutes of the state of Maine.
You don't
Otherwise,
think
why
we
would
look
have
at them
judges?
at the, you don't think we interpret the language of a contract, of a decree at the time, based on the law at the time?
But I believe what this court should be doing, I believe the appropriate analysis is to go with what 2117 dictates. It says, go look at the decree. Is there a provision in the decree for her to inherit? There is no such provision.
Can the adoptive parent go back to the probate court and say, hey, there was a consent here, it wasn't reflected in a decree, obviously it's a scrivener's error, and get the thing amended?
I suspect that might be true. She might also, in the interceding 29 years, have decided to write a will, and she did not, right? So, and again, circling back to the question about vested rights, Justice Meda, I agree with you. I believe I agree with the position I thought I was hearing. There are no vested rights until there is a decedent, and a lot of things can happen between an adoption decree.
But there's no reason to have it, to rewrite it if, in fact, you understand she's going to inherit. But you don't need to respond to that. That was a comment. Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.